Good afternoon, and welcome to the Appellate Division, First Department. Based on request, we currently have almost 6 hours of requested argument time. Please know that the court is fully familiar with your case, the record, the briefs. So please ask for only the time you need, not the time you want, so I don't have to do it for you. Okay. People versus Victor Castillo. We're off to a good start. Submitted. Lombardo versus 333 East 49th Partnership. Respondent, how much time? 2 minutes. Okay, 5, 2, and 3. Veziri versus Onder is submitted. People versus Johnson, submitted. Denton's U.S. versus Zhang. Okay. Okay, 6 and 2 and 7. Please know that the time the court gives is what we think is required, but know that the light is for you, not for us. If we have more questions, we go beyond that time, okay? Victoria's Secret and Herald Square owner, both cases will be called at the same time. Counsel? On behalf of Rohan PJ Counsel, Kevin Russell, first appeal, 6 minutes, 2 minutes. I'm calling both of them together, so give me time for both arguments together. 11 minutes and 4 minutes. Okay, and who's the respondent? Okay, you gentlemen have 7 and 2 and 8, and as I said, if we have more questions, we will continue. People versus Richardson, submitted. M. Everett, submitted. Kesey Lewaski versus New York City Health and Hospitals, and if I mangle the name, forgive me. Okay, let's do 5 and 3 and 7. New York City Transit and versus American Transit. Submitted. People versus Oscar Batista is submitted. Batish versus Gandhi. Okay, so I ask whether you can, wonderful, submission. People versus Lewis. Okay. 4 and 1 and 4. Rich versus J.A. Madison. 6 and 2, please. Okay. 6 and 2 and 5. Southwest Marine versus Falls Lake National. Do we need argument? I think we got it covered. Thank you so much. Submitted. People versus Frank Rogers. Submitted. And Aaron versus Kennedy, submitted. First case on the calendar, Lombardo versus 333 East 49th Street Partnership. I know. Is there a Pro Hoc Vici application?
I think they want you to.
So you can sit over there, sir. Respondent sits over there. No problem. It's okay. All right. You don't need much just to sit and wait. All right, 5 minutes. You may proceed, sir.
Thank you, Your Honor. Good afternoon for the appellant defendant, Ativ Winiarski from the law firm of Cook & Marino, Winiarski & Bittens. I would imagine the salient question to be asked in this case is, well, why does it matter? Specifically, why does it matter whether the plaintiff subtenant executes and seeks to enforce this order by virtue of Rent Stabilization Code 2526.1E, or if it started a plenary action? So it matters for two reasons. So the first reason it matters is we have decisional law precedent. Specifically, there's ample case law, which specifically states that.
Counsel, let's deal with the facts here.
Okay.
The tenant goes to DHCR, and DHCR doesn't certify the RN14 and suggests instead that they initiate a judicial proceeding. I don't frankly see the issue when DHCR is declining to do what it should do, for the tenant then to bring a action in court to convert essentially that order into a judgment.
So if we know the history of this case, which goes back to 2009.
I wrote the opinion, so I know
Right.
the history of the case.
So we know that DHCR has gotten it wrong in this case and had to be remanded multiple times going back to 2009. So when that has happened in the past, when we received an adverse decision which we believe was incorrect, you take a PAW, you do an Article 7.8, you take some action. The DHCR was simply wrong in failing to certify because they were under the impression that an order was only issued as against the tenant. Well, we know that's not correct. There was an order issued as against the tenant and the landlord, and they were jointly and severally liable. What the plaintiff had to do in that case was go back to the DHCR and say, hey, you got it wrong, so either we do a PAR, either we do an Article 78, or we take some action. But what they weren't entitled to do, pursuant to law in this department, decisions by this department, is you can't say, well, DHCR got it wrong, so now I'm just going to do what I believe to be correct, which is to commence the plenary action, even though the statute is very clear.
So the statute that you rely on is 2526.1E, correct?
Correct, yes, Your Honor.
Doesn't the statute use the word may? And doesn't that suggest that DHCR is not the exclusive means for enforcement?
If the statute says may in terms of this is how you can enforce the order. I would also note that if you look at the order itself says it's to be enforced as a judgment pursuant to the statute. And then there's a reference to DHCR fact sheet number 16, which doesn't use the language may, but you continually uses the language must. In other words, this is how the means in which you enforce the
So in
judgment.
other words, DHCR can amend the statute to changing a may to a must?
Yes.
Are you serious? That DHCR can amend the statute? By decision, they can amend the statute?
No, I'm sorry.
That's what you just said.
Maybe I misspoke. I'm saying the DHCR can amend the rent stabilization code. The rent stabilization code is written by the DHCR. So this is their procedures that they write, and if they wanted to amend it, and there are other statutes.
But you're saying that they can amend it by virtue of a decision rather than issuing a new mandate?
Then maybe I misspoke or I misunderstood. I don't mean to imply.
I just want to be clear on what
Yes.
you're arguing.
Do not mean to imply that by the decision they can amend the statute. But to the extent that the DHCR wanted to give the plaintiffs an opportunity to either commence a plenary action or seek to enforce the judgment by their procedures that they set forth in DHCR fact sheet number 16, that they could do.
So, counsel, what about the position that these regulations that we're looking at, they talk about landlord and tenant. This is tenant versus tenant, right? Because
Right.
what happened here was the owner leased it to the defendant tenant, who then subleased it to the plaintiff in this case, so that the rules and regulations, that, unless I missed it, they don't talk about a situation where tenant versus tenant, right? He's recovering. The recovery is going towards the tenant.
Justice Lang, you didn't miss a thing. You're absolutely correct. What the proper procedure that should have happened is the statute speaks to how to enforce it as against the landlord.
Right.
So to the extent that they sought to enforce the order as against the landlord, they had to
Right.
use the means employed by DHCR. To the extent that they wanted to commence an independent action as against a tenant, they were correct to do that, but they couldn't do it as against the owner.
Well, here,
In other words, under your theory is we have one way, we enforce the action against the tenant by a plenary proceeding and against the landlord through DHCR. There seems to be it just seems like a wasteful way of doing things.
I'll let you answer. Go ahead.
Yes, That's the statute, the way they have it written right now, that's the only way they would do it. But I would just want to add last thing before I finish up. I know my time is up, and it's the second matter why this is so important.
You can give us that on rebuttal.
Rebuttal, very
Nice
good
try,
job.
though. You may come up, sir.
Good afternoon, Your Honors. My name is Alan Goldberg. I'm with the firm of Goldberg and Lindenberg. We represent the respondent in this proceeding. I would just like to bring to the court's attention, as the court is well aware, the appellant went and subleased 23 rent-stabilized apartments to their co-defendant.
Counsel, the issue is how do we enforce the judgment at DHC?
Okay, 2526.1 is permissive. Okay, it's clear beyond doubt that Supreme Court has concurrent jurisdiction with the DHCR in determining rent overcharges. The 2526.1 remedy is not exclusive. As Your Honors correctly pointed out, it says may, not must. Now, in this situation, the appellant...
And on top of that, and over here, then on top of that, this is tenant versus tenant, so that if you went after the tenant, I guess the counsel is saying, you know, you're free to do that in terms of coming to plenary action. But in this case here, the landlord, I mean, not the owner is jointly and severally liable, so that, okay,
Absolutely.
yeah, go after the tenant, and then when you get a judgment, you could, in a joint and several liability session, if I remember, you can go whoever you want, right? And
Absolutely.
let the defendants figure out how they're going to.
Absolutely. And
split
may
the
I just
bill.
say, Your Honor, the appellant did not appeal the DHCR order finding it liable. They didn't file an Article 78 for whatever reason, I don't know. We went to the DHCR, we filed what we were supposed to do. DHCR said, hey, go to court and do this. And that's exactly what we did. There's no question that the courts have concurrent jurisdiction. There's no question that the DHCR has fully determined the issues. They chose not to appeal that. They
How do
chose-
you address the argument that the actual remedy should have been taking a par out against DHCR because there's no basis for DHCR not to give you the certification RN 14?
Your Honor, the DHCR said go to court, and that's exactly what we did. The court has concurrent jurisdiction. It should not act as a roadblock because the main thing is that the appellant had full opportunity to litigate every single issue in this case. And they chose not to go any further. They chose not to file the Article 78. They chose to accept the decision of the DHCR. DHCR says go to court. That's exactly what we did. We went in, we did a 3213. It was denied. We then did a 3212. Summary judgment was granted. And here we are right now.
Okay,
Thank you so much,
thank
Your
you so
Honors.
much.
I just want to quickly address the second matter, which is what I wanted to get to. And the second matter, and as to why this matters, is because when they fill out the RN 14-4, the most important thing, the one and only thing the DHCR asks is that you fill out the certification that says that you didn't receive an offset or there wasn't a rent credit. Now, why is that important? Because here you have, as you mentioned, Justice Soing, you have a case where we have joint and several liability. So it's very important that the tenant, at the very least, even if you wanted to argue, that the tenant was able to commence the action and to commence the plenary action, there had to be an affidavit from the party on a motion for summary judgment saying there's...
Well, wait a minute. I mean, the records in terms of an offset are also in the hands of the owner/tenant. I mean, the prime tenant, right? I mean, you guys know whether or not you've given an offset or not, correct?
That would not be correct, Your Honor. This was a direct relationship between the prime tenant and the subtenant.
Okay, so the prime tenant would have that information too, correct?
Yes, the prime tenant would have it, and the prime tenant didn't take a position, didn't appear in this action. And as to the subtenant, the certification on DHCR, even if you want
Well,
to
then that's between the owner and the prime tenant. The owner and the prime tenant, in terms of joint and several, I mean, can go after the prime tenant. I mean, that's something that I mentioned earlier. That's on you guys at that point.
But the owner has no way of knowing whether there was any offset provided. The owner has no way of knowing whether there was any rent waiver as between the prime and the sub. And that's why the DHCR asked, has there been an offset? So at the very least, on a motion for summary judgment, there should have been an affidavit which said there has been no offset. So to the extent that this court is inclined to say, you know what, you can use this procedure as against the owner, I think the motion should be denied with leave to renew to allow the
Well,
tenant to put in
that
an
sounds more like you gotta, that sounds like that, you know, the liability portion has already been resolved and it's only a matter of money then, right? I mean, that can be taken care of after the fact.
You have an order to pay $196,000. If there was an offset of $50,000, if there was the rent credit, that limits the owner's liability.
Right,
There
no,
had to-
I hear you, yeah.
So there had to be that affidavit, and you have a motion for summary judgment, and no affidavit was submitted in that respect.
Thank you.
And clearly, that's important for DHCR. Thank you, Your Honor,
Thank
for
you
your
so
time.
much. Denton's US LLP versus Jinsu John Zhang. You may proceed.
Thank you, Your Honor. Lyndon Treader, Wilmuth Martin Deutsch for the appellant, Mr. Zhang. We all agree that Mr. Zhang had no contacts with the New York Forum that would satisfy long-arm jurisdiction. His position is therefore simple.
Why don't we cut to the chase and deal with the last decision of the California court, which clearly said that, based on that decision, I don't know why we are here, sir.
Well, actually, Your Honor, the court said that the Labor Code did not automatically, the California Labor Code does not automatically render Zhang's alleged consent to the New York Forum void. What it did say is it was voidable. It could be either way. And what we say.
And it did say that the proper forum to decide these issues was the what's the initials?
CPR.
The CPR arbitration. That was very clear in their decision, that it was up to the CPR arbitration in the first instance to decide what was arbitrable, correct?
The court, and we do not disagree that there is a delegation clause. What we object to, Your Honor.
That wasn't my question. My question was whether that's what the California court decided, that it was up to the CPR arbitration to decide in the first instance whether it was arbitrable, whether the section with respect to whether Mr. Zhang is an employee for the purposes of the California statute had to be decided at the CPR arbitration level in New York.
No.
No?
No.
Tell me.
The court said that as a matter of California law, the issue of whether somebody is an employee and whether 925 applies is delegable to an arbitrator. And in this case, that they picked the CPR. However, the court did not say, and the court was not, and the California court was certainly not in a position to say that the New York court actually had in personam jurisdiction.
Except that the agreement that was signed by your client said that this action could be brought in either Chicago or New York.
Absolutely, and as a matter of California law, and the California court said that is voidable. It is not automatically void, it is voidable. Our only position here before Your Honors is that Justice Ostrager needed to himself consider the question of whether Section 925 applied. One can delegate.
So in other words, notwithstanding the California courts have spoken on this issue, the partnership agreements are pretty clear who decides this issue. It's your position that the New York courts have to decide the issue, correct?
That is correct, Your Honor, and my position is that a New York court...
What is the legal basis for that statement in light of the two California decisions and a plethora of law in this?
The legal basis is quite clear, Your Honor, and this court has ruled many times that a court must establish its in personam jurisdiction before it can act on the merits, okay? So we raised an issue whether there was a valid consent clause or not. Justice Ostrager needed to decide that. He could not delegate the question of his own jurisdiction to hold a special proceeding to an arbitrator on the grounds that there was a delegation clause on enforceability.
Counsel, I have a question.
Yes, Your
Let's say I buy your argument, and let's just say that, okay, Justice Oscar found what you're arguing, that 925 doesn't give him personal jurisdiction, doesn't give him
I'm sorry,
does not give him personal jurisdiction. Where are you going to be then at that point?
We would be in California, Your Honor. There was a proceeding in California at the time.
No,
So we should send it back and ignore the California court, is what you're arguing.
No, there was no sending back to be done, Your Honor. If I understand Justice Owings' question is, if Justice Ostrager had found that he did not have jurisdiction, what would have happened? Well, there was a lawsuit that was going forward in California, and is still there today. It would no longer be stayed, and they could have moved to compel, and the California court, if it felt that it would compel arbitration, it would. But somebody had to make the decision that a New York court, sitting in a special proceeding, had jurisdiction, and once the clause that was the only basis for jurisdiction was at least nominally, potentially void.
You're suggesting the California court punted it over to us. Is that
I'm
what?
suggesting that the California court didn't really decide the issue.
yeah, they
of whether
punted it to
The New York
us.
court had in personam jurisdiction.
Right. They threw it over to us to let us decide. That's what you're saying,
Counsel-
right?
Absolutely.
Counsel,
because
can I-
we're the New York courts.
Can I read to you from the November 9th, 2022?
I'm sorry, Your Honor. I'm having trouble through your
It's
math.
over here.
Oh,
Judge
okay.
Mendez here. Can I read to you from the November 9th, 2022 California court decision from the court?
Of course.
Okay, so it says, petitioner sought a writ of mandate, which we denied. The Supreme Court granted review and transferred the case back to us, directing us to issue an order to show cause. We did so, and now again deny the petition. We agree with the trial court that the parties delegated questions of arbitrability to the arbitrator. That's the first thing. So it's the arbitrator here that's supposed to decide.
I agree with
The
that.
He's still reading.
The arbitrability issues in this case should include whether petitioner is an employee who may invoke Labor Code Section 925 and require the merits of the dispute to be resolved in California instead of New York. So that's something for the arbitrator to decide. We reject petitioner's contention that because he invoked Section 925, the New York court is not a court of competent jurisdiction.
Your Honor, I'm glad you read that. I would just say, what the court said is that the mere invocation did not deprive, he used that appellate court decision used the word deprive the court of jurisdiction. What I'm saying is the court never examined its jurisdiction in the first instance.
Okay,
We
you
are
can
not-
continue on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court, Akiva Shapiro from Gibson, Dunn, and Crutcher. For the respondent, I just want to make three very quick points in response to the argument from my worthy adversary. Number one, we agree with the court that based on the California decision, there's really nothing left for this court to decide. As we heard from the bench, it decided the issues on point. It's California Appellate Court. Number two, the argument made that parties can't delegate the question of arbitrability to an arbitrator, and that has to be decided by the court first. That's not accurate. The Supreme Court in first options made very clear that the parties could, in fact, delegate the question of arbitrability to an arbitrator. The only
I don't think that's his argument, if I understood it, was that it was not so much that it was delegated, that the issue was delegated to the arbitrator. It was that the court itself, Supreme Court here in New York, had to decide first whether or not it could even say that. That's what he was saying.
I'm glad you asked that question, because that was my third point.
Right.
And just to finish the second point, that's exactly what they did here. It's R90 of the record that in the arbitration clause, all disputes of any kind, including relating to validity, breach, interpretation, and enforcement, go to the arbitrator, and they also incorporated those CPR rules, which make even more clear, even more explicit, that challenges to jurisdiction.
So am I understanding you correctly, had the Supreme Court actually entertained and decided these issues, it would have run afoul of the California court's decision that it was up to the arbitrator to decide those issues?
Exactly right. The California court explicitly said that it cannot be decided by a court because the parties agreed otherwise. That's at page 22 of their decision. And the final point, getting to that question, it is not accurate to say that Justice Ostrager did not issue or decide the threshold question of his own jurisdiction based on the arbitration agreement. Page 33 of the record, he said and held, quote, Mr. Zhang consented to jurisdiction of this court by virtue of executing the Denton's partnership agreement, which expressly vests jurisdiction in New York.
So in other words, they could be jurisdiction New York, Chicago, right? Essentially.
That's correct,
And,
yes.
and if you brought the action in, I don't know, Florida, then there would be an argument to say that the Florida court has no jurisdiction, but based on the venue provisions, jurisdiction is established in one of those places.
Yeah, it's very clear from 1210.
So I got a procedural question. You guys brought the petition to compel arbitration, correct?
Correct.
Why don't you just commence the arbitration and let him bring a petition to stay it?
Well, that's a great question, and we did in fact commence the arbitration. And after there was an initial hearing and a decision from the arbitrator to deny their request, his request to stay arbitration, Mr. Zhang actually submitted a letter through counsel to the arbitrator saying that he was, quote, withdrawing from the arbitration because of that decision. So we're forced.
And he then filed suit in California.
He then filed suit in California, and
okay,
that's why this
got
is,
it.
the whole forum shopping story that we're a year and a half later, and we still are just trying to get.
You're back at square one.
Arbitrator. There is an appointed arbitrator. As soon as he's compelled to appear, we'll have that arbitration. Obviously, the point of arbitration.
Well, but wait a minute. Before you have the arbitration, doesn't the arbitrator have to make the decisions that we've been discussing here with respect to the California statute, et cetera? That
Yeah,
decision
definitely. I'm glad you asked that question because the narrow issue here is just whether to send to the arbitrator that threshold question and any other questions.
And
all
ultimately,
his merits arguments.
and at the end of the day, the arbitrator could still rule in favor of Mr. Zhang. He could say, okay, 925 applies, goodbye.
That's correct. Of course, we don't think so, but he can present all of his arguments to the arbitrator, just as the parties bargained for in their arbitration agreement. The sophisticated parties, a sophisticated lawyer, an equity partner at a major international firm. He can make his arguments there, and come what may, of course, Denton's will abide by the arbitrator's decision.
I mean, the way I look at it, Supreme Court here in New York, it really is a pass-through because just based on what the California court said, there was really nothing more for him to do, for the Justice Ostrager to do, was just sign an order saying, go to arbitration. That was it. I mean, it was very easy. I mean, the California court made it very easy for him as to what he needed to do in this case.
100% correct. Of course, this court has independent authority to decide its own jurisdiction. You don't need a California court to tell you that you have jurisdiction, and neither did Justice Ostrager. And if Section 925 worked such that it could vitiate an arbitration agreement and that forum selection clause and force someone into California, that would be preempted by the FAA. And the California court made pretty clear that and agreed with that argument as well. We don't need to get there because that's not how 925 works in our understanding and interpretation. And so we just asked this court, look, it's been a year and a half. We're just trying to get into that threshold determination in front of the arbitrator. Unfortunately, we have a counterparty that has tried all kinds of procedural machinations, refused to show up, have brought meritless suits in California that have now been thrown out by the California courts. It's high time to proceed with the arbitration the parties bargained for, and we therefore...
Is that plenary action that he mentioned gone in California? He mentioned there's a plenary action in California. Did I mishear that?
There's a stayed action. Right now, that California decision that the court referenced will become final 30 days after issuance, which I believe is December 9th. He has a right to petition to the California Supreme Court. So in theory, he could ask the California Supreme Court to step in. We don't believe that is meritorious or that there's any reason the California Supreme Court would. It sent it back to the appellate court to issue this decision and decide this issue, which it did in a detailed, thorough and well-reasoned opinion. So we don't think there's any reason for the California Supreme Court to step in. But of course, as I said, this court doesn't need to wait for the California court to tell it that it has jurisdiction to enforce an arbitration agreement and order arbitration according to the provision's plain terms.
Thank you.
Thank you.
Okay, sir, you have 2 minutes.
Thank you, Your Honor. Your Honors, just as it would be improper, as the California court said, to apply Section 925 automatically, it is equally improper to assume the validity of the clause before it's been even decided. You can, and therefore...
But no one is assuming, I'm sorry, I just don't don't understand what you're saying, because no one is assuming the validity of anything. What we're trying to decide is what is the proper forum to make those decisions. That's the only issue before us.
Your Honor, I'm afraid it is assuming, it necessarily assumes, because the court, Justice Ostrager, had no power.
That's,
No power
Let me
to-
stop you again. I got a problem, because as my colleague pointed out, when you were up initially, there's a venue provision which allows partnership disputes to be brought in two venues, New York and Chicago. So the courts of both New York and Chicago, it seems to me, have at least initially jurisdiction to make those determinations.
Not so, Your Honor, unless there's a determination by the court that that clause is in fact valid. I mean,
The argument you're raising is what comes first, the chicken or the egg?
Exactly.
okay?
It's an
So
order
in
of-
this case here, guess what? The chicken came first.
all right, well,
I mean,
then-
right?
but Justice Oing, thank you. I think you get my argument.
I get your
It's an
argument,
order
but
of
I'm not
pri- it's a-
buying it.
It's an order of priority, and I believe that this court has always held that a court must establish its own personal jurisdiction
You're
before it
absolutely
gets
right.
to the merits.
You're absolutely right. This court, Supreme Court, had to establish its jurisdiction. Supreme Court in this state looked at the California court and decided, okay, you know what? Jurisdiction's here based on the fact that you either have to be in Chicago or New York, so not California. I'm sending you off to arbitration.
I thank the court for its time.
Thank you.
Thank you. Okay. Victoria's Secret versus Herald Square owner.
Good afternoon, Your Honors. My name is Matthew Yog of the law firm of David L. Fletcher Citron LLP, counsel for plaintiffs appellants Victoria's Secret Stores LLC and L Brands. Standing next to me is Kevin Russell of the law firm Goldstein Russell PC, who is a member of the Bar of the State of Maryland. Pursuant to this court's directive, today we have submitted, along with Mr. Russell's notices of appearance, a copy of the letters from this court granting plaintiffs' appellants' applications for permission to have Mr. Russell appear before this court pro hoc vice. Accordingly, plaintiffs' appellants respectfully request that this court permit Mr. Russell to argue this case.
Well, welcome, sir. And I will say to you what my esteemed colleague Angela Mazzarelli would always say with these applications. We have over 100,000 admitted attorneys in New York. I'm sure you could have found one, but welcome. And we look forward to your argument. You may proceed, sir. Your application is granted.
Thank you, Your Honors. May it please the Court, Kevin Russell on behalf of Appellant Victoria's Secret. It's uncontested that at the times relevant to the first appeal, during the midst of the pandemic, Appellee HSO could not have sought an order judicially evicting Victoria's Secret for non-payment of rent.
But does that mean you don't pay rent?
Excuse me?
Just because there's a moratorium, does that mean that you don't have an obligation to pay rent?
No, we had an obligation to pay rent. We eventually did pay the rent.
So my recollection is that they serve you with a notice to cure, right? Wouldn't that have been the time to go into court, get a Yellowstone injunction, or at least attempt to get a Yellowstone injunction? Wouldn't you have been in a different position today?
Perhaps we could have followed that course. We made a strategic decision not to do that because I had a good faith belief that the contract was subject to rescission. That turned out to be wrong, and we paid the price. We paid back all the rent that was due. We paid 18% interest at a time where the effective time value of money was zero. We're going to have to pay attorney's fees for that. The question here is whether they were entitled to, in addition to all of that, which made them completely whole, seek an order from the court requiring us to pay millions of dollars of damages every month we failed to self-evict.
So how do you sort of deal with our case law, which is pretty clear that we have permitted double damages, Second Department has permitted treble damages under similar circumstances? I guess it's the pandemic is what you're arguing, right? Is that what distinguishes it?
We have two separate arguments. One is the pandemic, that in these circumstances, ordering millions of dollars of liquidated damages every month we failed to self-evict contravened the public policy behind the eviction moratorium because it put pressure on us, and it effectively did, caused us to move out.
Well,
causing all the-
counsel, I'm over here, sorry. I hear what you're saying, but there was something that was in the record here during the oral argument that the landlord's counsel made, which struck me, saying, you know, they didn't pay rent, but my client had to continue to pay the mortgage bills that were coming in, had to continue to pay all the taxes that were coming in. We had expenses going out, but nothing was coming in. I recognize what you're saying in terms of what were you up against, but there's also the other side of the coin where they're getting nothing either. And, and then it's fine that you say, we paid up everything at the end. With that period of time where the landlord was getting no rental income at all, I mean, it's a two-way street, right?
Two responses to that. First, they were protected from foreclosure by the same order that we're relying on. Second, the point of the eviction
But that
moratorium.
doesn't change the fact, as my colleague just pointed out, that they had money going out
true.
for their mortgage and nothing coming in from contracts that they had in good faith entered into.
Right, we are in the same position as them, but the more important point is.
Yeah, but the problem is that you're in the same position, but they got a contract with you under a lease. So that's, in terms of your contract with your vendors, that's the dispute that you're going to have to work out on your own. Doesn't involve the landlord in this case, right? I mean, that's the whole, that's what business is all about. That's capitalism at its best, I guess.
But the governor made the determination that in order to protect the public, not out of some sense of equity among the landlords and tenants, but in order to protect the public, it was important not to send thousands of workers into hundreds of establishments during the height of the pandemic.
What does that have to do with you paying your obligations under a contract?
Because the eviction moratorium was premised on the assumption that the people protected by the order would have failed to pay their rent without legal excuse.
So in other words, you believe that the moratorium actually gave you a pass, you didn't have to pay rent. That was the strategy.
We had to pay the rent, but we were entitled to stay for a limited period of time without being coerced into leaving, which would involve hundreds of our workers spending thousands of hours at the height of the pandemic in closed quarters.
But then,
the
as
rest of
you
the public.
said, your clients made a strategic decision. Instead of going into court and seeking a Yellowstone injunction, which would have alleviated the pain they were going through, they do nothing and instead kind of sit back and wait for the eviction notice to hit them.
Well, with respect, I'm not sure that getting the Yellowstone injunction would have provided any relief to HSA.
No, because if you went for Yellowstone, you would have had probably pay UNO, and that's something you didn't want to do.
And it's interesting that you found trouble with my statement of that and didn't earlier, but you please
I apologize.
continue.
I apologize.
You go ahead.
We have the separate argument, which maybe I should turn to, which is that the liquidated damages provision in this case, as applied to a midterm termination, is unenforceable as a penalty, because in that circumstance, it provides a remedy that is duplicative of every form of injury that they could suffer in this circumstance.
I thought about that argument, and what kind of concerns me is that, yeah, you know what, that argument plays out very well, but in this case here, procedurally, just based on this record we have here, it just seems like, and you even said yourself, you made it, the choice you made was the wrong choice, and we end up paying for it. So that in that circumstances, why is it then that I have to view the liquidated damages clause as a penalty and not a payment for damages? Because it was a conscious choice on your part, and it didn't come out the way you wanted it to. So that's a little bit different from making the straight-up argument that it's a straight-up penalty.
Well, I don't think that it is with respect. In every
Follow
case,
what I had to say? I mean, you
I
followed?
did.
Okay.
I did. But in every case in which the courts refuse to enforce liquidated damages provision as a penalty, it's an agreement, it's a provision that the parties agreed to. And the question always is, in cases like 555 West James Street, the second department held that when the contract also provides a complete set of actual damages remedy, you can't enforce the liquidated damages provision, because the only role it plays in that circumstance is to
Yeah, but
coerce.
those facts are different. They don't, every case stands on its own in terms of the facts. It always boils down to the facts in terms of whether or not something is one thing or another.
Well, with respect, it boils down to the facts in these cases about the lease, the characteristics of the lease. And here,
And how you went about doing what you had to do, right? I mean, live by the sword, die by the sword,
I respectfully disagree with that, Your Honor. Here, the only measures of damages that could have arisen from us not immediately vacating after a midterm termination were use and occupancy, but that's already provided for through the deficiency damages provision. Interference with reletting, there's another provision with that. We had another provision that offered them attorney's fees. We had another provision that offered them interest. The only thing that isn't accounted for that they point to is this alleged disgorgement of the benefit, but that's never been a permissible purpose for our liquidated damages provision.
Thank you. You'll have time on rebuttal.
Good afternoon, Your Honor. Stephen Meister, Seelig.
Mr. Meister, can you address this latter argument raised by your adversary?
Yes, sure. It proceeds from a misapprehension of the lease, Your Honor. If you look at Section 18B1B, which is the section which allows the landlord to recover either deficiency damages monthly or on an accelerated basis, B2 and 3, that clause is then overridden in Article 21A of the lease, which is the 3 times holdover damages clause. And the relevant sentence in Article 21A says that if the landlord, if the tenant holds over, either after the expiration of the natural term or after the expiration of the shortened term by reason of a cure and notice of termination, once that happens, the landlord's sole remedy is to collect the 3 times damages, and therefore the Section 18 deficiency damages. In other words, there isn't a duty to mitigate, Justice Singh, as you well know, but for a commercial landlord, but nevertheless, one can't simply collect an accelerated rent without discounting with no credit. But the remedy for deficiency damages is superseded by the holdover damages clause, which is 21A, and therefore there is no duplication. The argument is specious.
What about the latter, or the former argument that, given the circumstances of the pandemic, that this is as a penalty for the reasons stated? Workers are not coming in, and it would jeopardize people to be in there at that time.
Sure. So what I would say to that, Justice Singh, is very simply this. The lease required, and we did in fact serve 2 notices, a cure notice, I think it was a 5-day cure notice and a 3-day termination notice, or may have been flipped around, but it was 5 days and 3 days. When they got the cure notice, which obviously preceded the termination notice, they knew this is a $20+ billion retailer with 2,500 stores globally, okay? They knew that they had bargained for, this was a 20-year lease with renewals, a 3 times holdover clause. And by the way, and I think this is worth mentioning, they sued. I didn't sue, even though we didn't get rent. I wasn't the plaintiff, I counterclaimed, of course. They began their suit on May 25th by way of a summons with notice. They then later in early June served their complaint seeking impossibility, seeking to rescind the lease on impossibility and frustration of purpose. After the May 25th summons with notice, where they were seeking rescission, which under law required them to vacate before they began the suit, but they didn't do that, we then served a cure notice. They could have paid, they had plenty of money, okay? They could have paid under protest, as Justice Barak noted, and frankly, as I noted below. They could have paid under protest, proceeded with their frustration and impossibility claims, and if they had been successful before the lower court on those rescission claims, then they would have gotten a refund from a net worth or a credit landlord. But they didn't do that, and they didn't do that for a reason. And the reason they didn't do it, Justice Manzanet pointed this out, and Justice Owing asked a question about it, we had to pay a mortgage. And yes, we were protected from a foreclosure standpoint, just as the executive order protected them from an ejectment action or a summary proceeding. But just as that executive order didn't protect them from holdover damages and contractual remedies, if we didn't pay, if SL Green did not pay that mortgage, they were exposed to massive default rate interest and to acceleration, okay? Those contractual remedies are parallel or analogous to the contractual remedies we have here. So we were forced to keep paying millions and millions of dollars for a very long period of time to avoid our contractual remedies. And meanwhile, they snubbed their nose at their contract. Why? Because they were trying to bring, this was a very stressful time. I'm sure everyone on the panel recalls March, April, May, June of 2020 was a strange time in the world. And many tenants weren't paying their rent, and building owners had mortgages, were subject to acceleration, were subject to default interest. Yes, maybe they weren't subject to foreclosure proceedings, but they wanted to bring my client to its knees in the context of a negotiation, which ensued but did not bear fruit. So this was a very strategic decision, and they should be held to the remedy that they agreed to. They're a uber-sophisticated party, an extremely well-capitalized.
Right, so the whole thing, a concept of the whole thing about the argument about it being a penalty, you got to look at the facts and circumstances before you make a determination if it's a penalty, because of what you just said, it's a calculated risk that they took. That takes away from the fact that it's a penalty and more of it's a business decision, and you know what? It didn't come up the way you wanted it.
Look, they had, and this is in the record, there was a deal with Sycamore Partners where they were going to buy this brand. This brand was failing. They wanted Bed Bath & Beyond to trade independent of this brand. They made a decision that they might find a strategic buyer who might want this global flagship store. So they didn't get out. They kept their alarms. They kept everything going. They kept their air conditioning in, and they were shopping for a buyer. It didn't work out, so now they come crying, COVID, it's
Well, that all
unfair.
goes to the factual analysis of whether or not it's a penalty and a liquidated damages, right?
And the lease was entered into in 2001, Justice Ong, okay, a decade or more before these events. And obviously, it's much more difficult if you're trying to understand what the market will be 20 years hence than if you have a 3-year lease and the market is, and it's 3 years later. So that's why the case law uniformly holds that this gross disproportionateness standard, which is, I think, the standard that applies to invalidate a holdover damages clause as an unenforceable penalty, is assessed at the time of the making of the lease, not at the time of the breach, or of the holdover. And in this particular case, they saw that and they knew, and they made this strategic decision. Many courts, Terry Nichols in this court and Federal Realty in the Second Department have upheld 3 times holdover damages clause. Justice Swain from the Southern District just upheld a June 2020 termination against the Gap in the same COVID period. So we don't think that there's any validity to the argument that I should say one other thing. The Court of Appeals has held that the burden is on the party seeking to invalidate a liquidated damages clause as a penalty. And they didn't put in any evidence below as to this disproportionateness, and therefore, even if one were to consider it, I think they failed to carry their burden. Thank you, Your Honor.
Thank you so much. You have 2 minutes, sir.
Thank you, Your Honors. A couple points. All of this talk about Victoria's Secret engaging in bad faith and what we did before was not the subject of any discovery or findings by the court below, because nobody presented that evidence.
No, I'm not disagreeing with, I'm just getting back to your point about this liquidated damages, 3 times the rent is more of a penalty rather than a liquidated damages. It's just hard for me to accept that when the resulting, what resulted here was based on a business decision. Somebody made some decisions that didn't go their way, and now you're asking the court to say, you know what, that holdover provision is unenforceable penalty. Well, that's not exactly how the facts played out here. I mean, it was a business decision made. I mean, that's all, that's what these contracts are for. Sophisticated parties make a call, and you can't run into court now and say, oh, it's a penalty because, you know, our decision didn't pan out.
No, it's a penalty because it is duplicative of the other provisions of the lease that already provide a full remedy. That is what the court.
Your adversary's point there is that it's not duplicative, but the provision that, the triggering provision is the holder of treble damages provision under the circumstances here.
I would urge you to look at that lease provision. It does not say that. In addition, the point isn't that that they're allowed to get both. The fact that they have provided for actual damages for every measure of compensable harm shows that it wasn't unascertainable at the time. The parties were able to negotiate provisions for actual damages for every method or every mode of injury that could arise in this special circumstances. All the other cases that they're citing
Well,
to
sure. I mean, yeah, when you, just from my memory of commercial landlord tenant cases, sure, when you're a holdover, you're right, the UNO going forward is whatever the rent was. But in this case here, the contract doesn't call for UNO. It calls for 3 times the rent. I mean, so, yeah, okay, there you go.
If I could.
I'll allow you to respond, but you're out of time, so please keep it brief.
I will, just to return one moment back to the pandemic, and that is, the pandemic order was to protect the public, not to work equities between the party. Their position would allow a defendant or a landlord, through liquidated penalties, threats, to force people in our position to send workers into the street in close quarters with each other at great injury to the public health, which is exactly what the eviction moratorium was intended to prevent.
Thank you. Kisilawaska versus New York City Health and Hospital. And again, my apologies for mangling the name. I'm sure I did. You may proceed when you're ready.
Good afternoon, Your Honors. I'm Robert Epstein, representing Maria Kizliska in this action. The issue in this action really is, once a notice of claim is filed and a case is in suit where the plaintiff and the patient continues to treat for the same condition at the same hospital, and then more malpractice.
Counsel, these are 2 separate surgeries. That's the problem with your second bill in particular. The first one was a I don't even want to say the word, but it was a certain kind of surgery, and then the other one was the incorrectly sized implant. So didn't you need a new notice of claim? Don't you need a new, an amended complaint before you can slip that into this lawsuit, this claim?
Well, it was our understanding under the general municipal law that it's a prerequisite to an action. And that, in other words, you can't bring the action without bringing the notice of claim. The notice of claim said the treatment was about what was happening with respect to the care and treatment with her left leg.
But there's no mention in that notice of claim of the surgery of October 15, 2015. There's no mention of that surgery in your notice of claim.
The surgery
The second
itself,
surgery.
the first surgery,
You mentioned the first
Second
one, but not the
surgery.
second surgery.
oh, the second surgery, well, it's not in the notice of claim because it hadn't occurred yet. Your Honor.
So it's your argument that it's a sequela? Is that what your argument is? It's a sequela, that the second surgery is a sequela of what happened in the first surgery?
Basically, it's a continuation of the same malpractice, the maltreatment.
But that, it's different surgeries. Second surgery, as I understand it, the prosthesis was wrong. That's a different kind of malpractice. There had to be a third surgery. So
Well,
I don't see the relationship between
if,
three.
it's all claim, basically, that if the first surgery had been done right, she wouldn't need the second surgery. If the second surgery had been done right, she wouldn't need the third surgery. So I guess we are saying, I can't say the word properly, sequela. It's a normal outflow of what's occurring. Your Honor. In other words,
Putting in during a second, I believe it's the second surgery that the plantar was missized?
it was a total knee replacement, and apparently it came out later on that it was a missized patella that was put in there. Right after the surgery, nobody knew that it was continuation of malpractice. That would have just been another injury, basically, based upon the first, the treatment that happened before, Your Honor, Your Honors. But if we had put in a proper notice of claim,
How long after the second surgery was it understood that there was a problem with that second surgery? What is the span in time between the second surgery and the understanding that something went very wrong during that second surgery?
well, it wasn't clear that there was malpractice that occurred.
You're not listening to my question. How long between the surgery and your discovery that there was an issue with that second surgery?
Plaintiff's discovery would have been during the third, right after the third surgery or right before, which would have been exactly on
August 2016?
August 4th of 2016, Your Honors, yes. Okay, because at that point, there's an operative report, and it says that.
Well, shouldn't you have filed a new notice of claim at that time with
That was
respect to
my
that
point.
surgery?
Thank you.
And try
Trying
to
to get
relate
there.
it back to the first surgery.
Well, at that point, Your Honor, that surgery was done at a separate hospital, although it's New York City Health and Hospitals Corporation. And I suppose that's the,
And doesn't the fact that it's done at a different hospital, and by virtue of that, I'm assuming done by different doctors, why would you not have needed to file another notice of claim on the second issue?
well, the second surgery was done by the same doctors. The third surgery was done at the other hospital, Your Honor.
Okay.
I understand if it was a separate hospital, if it was a different part of the body, it's the same treatment for the same thing that just continued. The purpose of a notice of claim is to investigate, the investigation
We know
occurred.
the purpose. You'll have 2 minutes on rebuttal.
Thank you, Your Honor.
Thank you. You may proceed.
Good afternoon, Your Honors. May it please the Court, Jeremy Pepper for the Health and Hospitals Corporation. This Court should affirm the below order because the appellant did not, as you've just been discussing, he did not raise any claims of malpractice as to the second 2015.
So why isn't it a good argument to say that the second and third surgeries were natural sequela of the first surgery? Because after all, HHC was treating the knee.
Right. So I think I look at it as whether or not the appellant could claim that the second surgery and the third surgery came from the alleged mistakes from the first surgery for the purposes of damages is not at issue here. He's sort of trying to create a second chance at liability through this second surgery. Presumably, this case eventually will go to trial, and the appellant will have to prove to a jury that HHC doctors committed malpractice. According to his notice of claim and complaint, the one opportunity for him to do that is in connection with this 2014 surgery and the care involved with that.
Although I got to tell you, putting in the wrong size patella is not, it's not blame-free on the part of your client.
Justice Menzinet, I'm not going to get into whether or not the second surgery was negligent or not. That's not the issue here. The issue here is whether or not he properly, notified the HHC of that claim and properly pled it in his complaint, which he did not.
Doesn't the HHC know by virtue of the fact that they had to correct the problem with the third surgery? I mean, it seems obvious, right? If I have a second surgery and HHC botches that, and I have to have a third surgery, you are absolutely on notice that the second surgery was a problem.
The third surgery was at a different hospital, as you mentioned.
It doesn't matter.
What does matter is that this court has held many times in order to sustain an action against the HHC, they need to, the plaintiff needs to serve a notice of claim, you know, mentioning the time, place, manner where the incident happened. Whether or not the HHC did a subsequent surgery to repair that doesn't mean they were on notice. It was different. It may have been different doctors. It was in a different
Are you
hospital.
saying that after a HHC patient has a knee surgery that has to be corrected by a third surgery, that's not notice to HHC that they did something wrong on the second surgery? At least arguably,
I'm saying that
whether you agree with it or not, clearly that shows there's an issue.
It doesn't amplify his complaint to include that allegation in his
Except that
complaint.
you have all the records.
But he still has to include it in his pleadings. This court has never held that you can just create a claim later in litigation that has never been included in a pleading. He would still have to
Well, he
amend his
couldn't have
complaint.
pled it because the second and third surgery had not happened yet, correct?
could have amended-
So what he had to do was amend.
Correct, which he did not.
Okay.
Which there's no law saying that,
Well,
again,
that's the real argument, that he didn't amend, not that he didn't plead, because it hadn't happened yet.
fine. But functionally, he didn't plead because it was never included in a pleading initially or amended.
Well, it couldn't have been. Counsel, you
Fair.
keep on arguing something that is factually impossible.
I'm sorry, I'm going down the rabbit hole a little bit, Your Honor, but.
I think so.
He never amended, that's fair, that's a fair statement that he never amended, and he could have. You were asking about dates. You know, he just admitted up here that they were aware of this second surgery in 2016. They did not notify the HHC of any allegations about that second surgery until 2021, over almost 6 years later. And
When
at
was
that
the
point-
third surgery?
I think he said when he was up here it was in 2016.
August 14th.
So you would have known that there was a corrective surgery of the second one because she had a third one years before 2021.
At a different hospital with different doctors, but
But an HHC hospital.
it was never included in any litigation documents till over 6 years later. And at that point, that supplemental BP, the HHC moved to compel them to file a supplemental BP. If we hadn't moved, who knows if they would have ever alleged it in any filings until, like, you know, we get to trial and they start bringing it up. Who knows? There was never an opportunity for the HHC to conduct discovery about allegations. We went through all the depositions. We had completed depositions. We never had an opportunity to ask the plaintiff or any of the doctors that were produced about those surgeries. You know, just depositions were over. The city moved to compel the appellant to, you know, supplement their BP. All of a sudden, this allegation comes out of nowhere. As the lower court held, you know, you're right that the third surgery came in and it was I mean, according to the documents, they had to do that to correct it. But as far as the everyday, you know, operations of a hospital go, they don't assume that anything is malpractice. It could be there could be any number of reasons why something doesn't go right.
Okay.
And unless it's alleged, there's no way that the HHC would be on notice of those claims against them. Just furthermore, I just want to note one thing before I sit down. This language that's in their notice of claim and complaint, the prior and subsequent thereto, they list a specific date range where their alleged malpractice happened. It's different depending on the filing, but it's specific and it does not include when the second surgery happened. They try to stretch it into the ends of eternity by saying prior and subsequent thereto. This court has specifically held in Carroll v. New York City Health and Hospitals Corp. that that's not sufficient to put the HHC on notice. So I would just point this court to that case. If there are no other questions, I'll rest on my brief. Thank you.
Thank you. Yeah, you yelled out. Okay, you have 2 minutes, sir.
I'm not sure where to begin. His argument is basically a post-note of issue argument. This is a pre-note of issue argument that we have. Number two, the summons and complaint specifically noticed.
I don't think it's a question of post-note of issue or pre-note of issue. The problem you have is when you're suing the HHC, you have a notice of claim requirement. And here you have a new claim that you didn't file a notice of claim for or seek to amend the one you had filed. And explain to me why that's not fatal here.
Well, Your Honor, my understanding of GML sub 6 of I have it right here. A little nervous.
We know what you're talking about. Continue.
Is that it's due to a mistake in error, or in other words, it's blue, it's not black.
But you haven't done anything. I think that's the point that my colleague is making. You didn't move to amend, you didn't, for example, you could have made a motion or taken on order of show cause for leave to file a late notice of claim. You have done none of those things. Rather, you're attempting in your bill of particulars to bring in new claims.
Well, if we had moved to amend, okay, I think that we'd have the same thing about a nuclear reliability that they're arguing, then you can't do that past the time of a notice of claim. Second of all, under the amendment of a BP, which is
You can amend a BP, but you cannot add a new claim that wasn't in the notice of claim in a BP, which is your problem. This is a new claim.
it's
It's an injury resulting from a second surgery,
which is a constant.
which is different from the first one.
It is a second surgery, but it's on the left leg, the same spot, the same thing is trying to be corrected. It's not, for example, the right leg.
Got it. We got it. Thank you
Your
so
Honor.
much.
Thank you.
Thank you so much. Okay. People, Kiselawaska versus, no, that was the one we just did. People versus Mark Lewis. Like I did that already. You may proceed.
Good afternoon, Your Honors. Nicole Gioglis for Appellant Mark Lewis. 25 years on from his registrable offense, with more than 2 decades at liberty without reoffending, Mark Lewis poses a low risk of sexual recidivism. By only modifying his risk level to level 2, the Sora Court...
How long has he been in the community?
He was released from prison in 2000, completed parole in 2001. He lived in a supportive mental health institution until 2008, and then transitioned into the community and has been in the community since.
Since 2008?
Yes. He did, full disclosure, as is available in the record, due to a registration violation, he did have a 90-day jail sentence that he served, but outside of that, he's been in the community without any sexual reoffending the remainder of that time.
So what are the mitigating circumstances that you believe that we should consider to reduce it to a level 1?
The strongest and primary mitigating circumstance would be the fact that in the 25 years since the offense and 22 years that he had been in the community, he has not sexually reoffended. He's not been arrested or convicted of any sexual or violent offense.
Has he, I'm sorry, go ahead. Has he availed himself, for example, for treatment, for mental health treatment?
While he was in the institution that I mentioned, he completed 5.5 years of daily sex offender treatment, as well as other individual counseling. At the time of the petition, he was not engaged in mental health treatment, though he did have access to it in the event that he felt that he needed that support. In addition to his...
Has he ever been on psychomedication?
He had...
To manage his schizoaffective disorder?
He had been diagnosed with schizoaffective disorder at one time, and he had taken...
I'm not aware that that goes away.
Well...
I understand, based on my understanding, is that schizoaffective disorder is something you live with for life, and that you have to treat and manage for life. So how is he treating and managing his disorder?
He is living in the community. At the time of the petition, he was not on any psychiatric medication, but he was,
Is he in therapy? Does he
was-
see a psychologist on a regular basis? Something. So it seems to me that a court would like to, when someone has a firm diagnosis of a mental health condition, that either they are under continuous mental health care or are on some kind of medication that helps maintain their conditions so that they don't engage in aberrant behavior. So which of the two is he engaging in, if any?
he was not engaging in either, but he was also not engaging in aberrant behavior, which indicated that perhaps he did not need to be engaged in either. It is possible to struggle or to have a mental illness and not need lifelong therapy or lifelong medication. And the
Okay.
fact that he was not engaging in aberrant behavior is an indication of his low risk.
Thank you. You'll have time on rebuttal. You may proceed.
Your Honors, and may it please the Court, Anna Notchik for the people. The court below recognized the progress defendant has made since his underlying sex conviction and modified his risk level to level 2, declining to further modify it to level 1.
Also,
Defendant,
the defendant makes the point that he's in an SRO right now, and if he went to level 1, he would be eligible for programs that have a more complete array of mental health services. And so wouldn't it be more therapeutic and maybe safer for society to put him at level 1 so that he could avail himself of those types of services?
well, Your Honor, we would argue that defendant did not present clear and convincing evidence to show that a level 2 adjudication would be insufficient to obtain supportive housing. Defense counsel below.
There's no question that the higher level you have, the harder it is to find housing, because level 2 prevents you from living near schools, near et cetera, right?
Well,
Whereas level 1 has less restrictions so that finding proper housing is easier.
Well, level 2 does not restrict someone from living within 1,000 feet of a school, but level 1, we do admit, has less restrictions. However, defense counsel did state below that a level 2 would certainly make things easier for defendant. Therefore, we would argue that there was not sufficient evidence to show a level 2 adjudication would be insufficient. Additionally, the judge below was right to be concerned about defendant's lack of mental health treatment. As the board noted, defendant's underlying psychiatric problems are what led to the offense in this case and his prior criminal history. Because of that, the judge did take that into account in modifying defendant's risk level only to level 2. And if there are no further questions.
Well, I have a question. What about the fact, your adversary points out that the adjudication goes back over 2 decades, and he has been, except for a short time, stayed out of trouble. Is that something that we should consider in deciding whether or not to reduce?
Well, Your Honor, we would argue that that was considered below, and that's why the judge modified his risk level to level 2 and declined to further modify it to level 1, because the possible harm that defendant would pose if he did reoffend would be severe. And if there are no further questions, we ask that you affirm. Thank you.
Thank you.
Thank you. I would note with respect to the questions regarding housing that part of the error in the Sora Court's decision below was the court's refusal to even consider the impact of him being eligible to housing in the totality of the circumstances.
Is his girlfriend, who is supportive, according to the record, living somewhere where he could move into if he were reduced to a level 1?
I do not believe so. My understanding, based on the information included in his partner's letter, is that she is also living in housing through the Department of Homelessness Services, through DHS. So that was not something that I think was
One of the
offered.
issues. Okay.
The goal would be to use a voucher that he had been given to find supportive housing that he would be able to live in individually.
Got it.
And as the caseworkers, including the caseworker who attended the proceedings and spoke, explained, the level 1 would be very meaningful, and in part because given that he has been registered for as long as he has, with a level 1 registration, he would potentially be off of the registry, which would open up, obviously, a wide array of housing options.
Thank you so
Thank you,
much.
Your Honor.
And last but not least, Rich versus J.A. Madison. You may proceed.
Thank you. Good afternoon, Your Honors. May it please the Court. My name is Stephen Kaplan, and I represent the appellants who are the defendants in the court below. There are two parts to this appeal, Your Honors. The first one deals with the lower court's denial of the motion for summary judgment dismissing the veil-piercing claim against Jonathan Adler Enterprises, which I'll
Why
refer.
isn't that made out?
I'm sorry?
Why is that not fully made out on this record?
Why? I'm sorry. Why is what not made out?
Isn't there an issue of fact that there's alter ego liability?
Oh, okay. I'm sorry. I misunderstood, Your Honor.
I understand.
Well,
Yes,
okay.
I'm responding to what he just said.
But the answer to the question, Your Honor, is that when you, the analysis for piercing the veil under Scansa, there's a two-pronged analysis. The first is, was there complete domination of the corporation by the party against whom piercing is sought? And
So let me stop you for a second. Did the tenant in this case have a separate bank account, for example?
At the time of the lease or at the time of the alleged breach? Well, I'll answer it this way, Your Honor. The answer is no. I don't think that's dispositive.
And how much money was being generated? This is a major retailer, right? Probably hundreds, thousands, tens of thousands of dollars a day comes in and then just goes off to some other bank account?
No, Your Honor. What the answer to that is that the entire Adler organization has an asset-based loan, and under the asset-based loan, like most asset-based loans, you have centralized bank account with one sweep account in the parent entity, and all banking on behalf of all the subsidiaries, which were all separate borrowers.
So in other words, the parent and the subsidiary essentially were commingling funds. I mean, that all the funds of the subsidiary were going into the bank account of the parent.
No, I don't agree with that, Your
Not
Honor.
commingling? Or could one, at least, would it raise an issue of fact as to commingling? I understand you have a defense to that, but isn't that something that we do at trial as opposed to on summary judgment?
Right, so my main point here is, remember, there's a two-pronged analysis. The first is whether there was domination. All the discussion that we just had are having goes to the first point. The reason that we believe that the lower court made a mistake by denying this motion was based on the second prong mostly. There is no evidence, not argued or in the record or otherwise, that the second prong, which is that there was a fraud or other wrongdoing committed that created this liability. So, for example, and Your Honor,
Could it be argued that that your client, the parent, caused a breach of the underlying agreements, and that would be the wrongdoing, maybe not fraud, but wrongdoing in this case?
Your Honor, A, it wasn't argued. B, and I understand, I have the Parlux Fragrances case, the New York City waterfront development case in front of me. You're on those panels, Your Honor. The breach of the contract is not sufficient for the fraud or wrong component of a veil piercing to be satisfied. So even if hypothetically, and it's not argued, and there's no evidence of this fact, but hypothetically, if the parent, Enterprises, caused the sub to breach the contract, that is insufficient. That's a quote from the waterfront case, Your Honor, New York City waterfront. I can read the site in. I know you're familiar with it. You sat on the panel. 206 AD 3rd, 565. That's from Parlux Fragrances. That's from Kahan. Those are all First Department cases where it was specifically held that in the event that a parent or the party against whom veil piercing is sought causes the breach, that is insufficient. That is not a fraud. That is not a wrongdoing that rises to the level necessary to pierce a corporate veil, which is a very
What about the
narrow-
dissolution? What about the dissolution of A.J. Madison by JAE, which basically leaves the plaintiff without recourse in the event that they have a judgment, without recourse of anyone to go after?
I don't know that that's true. That's not a fact in the record. I don't know that that's true or not, and I
Well, was it
admit
dissolved?
respectfully-
I'm sorry, is my colleague right that there was a dissolution?
Later on, yes, there was a dissolution because that
So let's assume there's a judgment then. Well, what's the recourse?
I don't.
Parent, the subsidiary sends all its money to the parent. The parent dissolves the subsidiary. Plaintiff gets the judgment, hypothetically, of X amount. Who can it turn to? Couldn't one then argue that that's the wrongdoing?
Your Honor, that's not been argued, number one. Number two, that is not what happened. The Madison subsidiary was a separate borrower under their loan facility. The plaintiffs knew very well they were dealing with a separate entity. There are 3 agreements that they all signed where Jonathan Adler Enterprises and J.A. Madison were separate parties with separate signatures. They knew what they were dealing with. There's no fraudulent conveyance claim.
But
that would be the remedy if, Your Honor.
But we're not saying that we're saying that there's an issue of fact. That's what they're arguing, that there's an issue of fact. That's what the court decided.
Well,
There's an issue of fact.
Actually, Your Honor, what the court decided was that there was issues of fact as to the first prong. On the second prong, the lower court, Justice Hagler, said, I am unfamiliar with a case where this issue was disposed of on summary judgment, which we know from the New York City waterfront case was a 30-11 motion. Parlux Fragrances was summary judgment. Cahan was summary judgment, all on the same basis that there was no evidence from which a reasonable juror could conclude that there was a fraud or wrongdoing.
Okay, you have time on rebuttal.
Thank you very much, Your Honors.
You may proceed.
Good afternoon, Your Honors. May it please the court, my name is Elizabeth Sandercock, and I represent the plaintiff respondents, George and Regina Rich, in this matter. I just want to start addressing the issues raised by opposing counsel. First,
let me ask you, let me stop you right there.
Yes.
I'll get right to the point. If I heard his argument correctly, the veil piercing concept that you're pushing forward that the Supreme Court found as a factual issue, he's saying that, you know, in contract cases, that's not available. It's only available in tort cases. Do you have in your complaint, I don't have it in front of me, I just don't remember, do you have allegations in there that support that position, that there's some tortious conduct that was committed or perpetrated by the defendant, the parent here?
Your Honor,
That's if I buy his argument. I'm just trying to.
Exactly.
I'm just putting it out there.
yeah, in response, I'd like to say that actually the appellants never raised the liability of Jonathan Adler Enterprises in their answer to the complaint. It only came up when we made a motion for summary judgment in July of 2020. So,
same question, with respect to your motion now.
Yes.
With respect to the second prong, because your adversary essentially concedes probably correctly the first prong, how have you shown there's an issue of fact as to fraud or other wrongdoing sufficient for alter ego liability?
Your Honor, well, one, I would point you to this court's decision in BP 399 Park Avenue LLC versus Pret 399 Park, which I think mirrors the facts of this case very well. In that case, a subsidiary of Pret a Manger entered into a lease on Park Avenue, and then the rent payments were taken over by the parent company, who then stopped paying the rent. This court found that the parent company's decision to breach the lease and stop paying the rent was sufficient to establish wrongdoing.
Did you raise that before Supreme Court below?
Yes, Your Honor. That the issue of Jonathan Adler Enterprises' decision to stop paying the rent was raised below, as was the issue that during the course of, we did not raise the issue of the dissolution of Jonathan Adler, J.A. Madison, in our complaint because J.A. Madison was dissolved after our clients started the action.
I get your argument. You're saying, like the case you cited, the situation here is that it wasn't the tenant that breached the contract, but it was the parent who took over the tenant's obligations that committed the wrong by not paying the rent.
Yes.
By not paying the rent, but not paying out on this contract. And that's the wrong that allows you to support your piercing the corporate veil argument.
Yes, yes, Justice Oing, and I would also point out that every payment was made by Jonathan Adler Enterprises. Every payment was made by them, and in fact, the notification to our clients that...
And they made those payments notwithstanding the fact that they were not a signator on that agreement, correct?
Exactly, and the notification...
By withholding it, that's the wrong.
Yes, Your Honor, yes, thank you. And the notification to our clients that payments were not going to be continuing not because of their failure to provide consulting services, but simply because Jonathan Adler Enterprises was having financial difficulty, came from the controller of Jonathan Adler Enterprises herself. No employee of J.A. Madison was ever involved in making these payments or engaging with our clients and requesting these so-called consulting services.
Well, did they also commingle, if we're going to use that word, employees? They used the same employees for JAE with the same employees for J.A. Madison.
Yes, Your Honor, as to the extent that that is established on the record, appellants failed to introduce any evidence that there were separate employees of J.A. Madison. We pointed out that David Frankel, at the time of the agreement, was the president of both Jonathan Adler Enterprises and J.A. Madison. Same address? Same business address, same telephone number. It was not simply the service of process address, as was raised in the appellant's brief, but was their business office. And in fact, if you looked up the other subsidiaries of Jonathan Adler Enterprises, it followed the same pattern. They all had the same address. Alter ego is the familiar phrase in this line of cases, but they also refer to it as a subsidiary being run as a mere department. And I think that's a very good phrase in this particular case, because J.A. Madison appears to have been run as a mere department of Jonathan Adler Enterprises and not as its own entity that was set up in any way.
Was that argument raised below?
Yes, Your Honor. It was not set up in any way to meet the obligations of this agreement. If the court has no further questions, I'll rest. Thank you very much.
Thank you so much. You have 2 minutes, sir.
Your Honors, we've just had a good amount of conversation, all going to prong one of the analysis. At the opening of my colleague's argument, the question was, what was the wrong? What is the evidence of the wrong? And I know this record, and there's no evidence in this record that there was any fraudulent or wrongful conduct. And to bring up the BP Pret-a-Manger case is entirely different. In the BP case, there was record proof that the parent entity was actually operating and engaged in wrongful...
But let me stop you for a second. No one is suggesting that your adversary is entitled to summary judgment. As my colleague pointed out, all we're talking about, doesn't this record raise an issue of fact?
Correct, and I appreciate that, Your Honor. But what I'm saying is on prong two, there's a record. This is what we have, not arguments of counsel, not briefs. We have the facts that are in here, and there is not one fact, either documentary evidence or testimonial evidence, that there was wrongful or fraudulent conduct, and I'll even go more specific and say that there's no evidence whatsoever, documentary or testimonial, that Jonathan Adler Enterprises caused J.A. Madison to stop paying money under the consulting agreement. And even if it did...
But it was JAE that made the payments, and it was JAE that stopped
I'm sorry, I didn't hear you, Your Honor.
Wasn't it JAE that made the payments on behalf of J.A. Madison?
JAE was the only entity that was allowed to have a bank
Exactly.
account under yes, but that doesn't mean that JAE caused J.A. Madison to stop. But my bigger.
But J.A. Madison never made a payment. It was always JAE.
It was made, the funds were advanced out of a JAE bank account under the loan facility. But more importantly, what I'm trying to get to, Your Honor, is that whether it's under Kahan, whether it's under Parlux Fragrances, and whether you go New York City Waterfront, any of these other similar cases, and I'll quote from these opinions, if the party against whom veil piercing is sought caused the contracting party to breach, that is not sufficient conduct. It's quoted.
All right, thank you. You have made these arguments 3 times. Thank you so much. Have a good night.
Thank you, Your Honors. I appreciate your time. Thank you, you too.